Obviously, we'll have some proponents and perhaps some opponents. Are you opponents to the bill? Okay, if the opponents will take a seat, and there are 4 of you.
Lady
5
Chair.
of you? Okay.
So,
who are
I don't have a problem with it.
Who are the proponents of the bill? We have 1 proponent of the bill. Okay. Thank you, ladies and gentlemen. We appreciate that. And we have a proponent of the bill, Senator Fowler. Welcome.
Thank you. Thank you. My name's David Fowler, President of the Family Action of Tennessee. Appreciate the opportunity to speak, and I figured it was 6 times 5 minutes, so I get 30. I just want to point out a couple of things. I hope you know where you are, but I appreciate each of these fields. There are times that all of us need counseling. There have been times that I've needed it. There have been times that I actually wanted the counselor to tell me what they actually thought, because I was there because I didn't know what to think. To help me discover what I should think when I didn't know what to think was sort of pointless. I needed somebody to say, here's what I think. And then let me decide if I wanted to think that. But there's something in my law practice I used to do, and I learned in a big city, that when you'd call an attorney and say, hey, do you mind giving me 30 days to file this answer to this complaint? He said, oh, yeah, that's fine. And I said, well, let me send over an agreed order so we can file it at the court, just in case, at some point we forget our... No, we don't need to do that. We don't need to do that. And I always wondered, well, if you're willing to do it, then why aren't you willing to put it down in writing? Now, what I hear here is that we're not going to violate anybody's religious beliefs, but yet I hear testimony that says that we might actually need to do that. Now, if you're not going to do it, then there's no problem in saying you're not going to do it. Let's put it down in writing. If they're not doing it, then this bill doesn't interfere with anything they're doing. They shouldn't have any problem in saying so. Just like my attorney friend shouldn't mind if he said he would do something, putting it in an order. Now, I've heard here that you give up your right when you become into one of these professions. And you are free to give up any right you want, but the government is not free to take them from you or interfere with them. And if the only way that you can be a psychologist is to give up to your First Amendment rights, then we have a much bigger problem than is evidenced by this bill. Now, I've heard lots of things that to me were red herrings. For example, the veteran and the Quaker. This bill does not say that I can establish categories of people I will not see. It says only if the goal, the outcome, or the behavior to be obtained is one that I cannot in good conscience do. If the Quaker is dealing with the veteran who has fought in a war and his problem is grief, then I would hope that a Quaker would say, I understand grief and I can help you work through that. If the Quaker, however, is being asked, to help somebody figure out how to kill people, then I would hope we would respect his right to not have to counsel them how to do that. Now, ladies and gentlemen, I also heard that we are giving some kind of a conscientious objection to curriculum. I would submit that those who would say that should actually go back and take remedial reading classes. It says goals, outcome, and behavior in counseling, not in any classwork. You want to have a class on God is dead? You got to take the class. But what we're talking about here is the government compelling you to speak beliefs that you do not hold. Compelling you to say something that, this is okay or this is all right, and you don't believe it's okay or all right. And if you got to do that to be a psychologist, you're in trouble. In fact, our country's in trouble, because that's what the First Amendment says you cannot make me do. I have the freedom to say what I want to do, and I have the freedom to not be compelled to speak beliefs that are not mine. And the other thing that I would mention in just closing, there's more that I could say. But we do kind of know what would happen if a bill like this passed, because Arizona passed one in 2011. And there have been no challenge to their accreditation. They've not lost their accreditation. And in fact, when I talked with the Alliance Defense Fund attorneys who wrote an opinion that should have been in the packets that I gave you, they said, you know, if a private, unaccountable, unelected body can force the state government to violate your First Amendment rights, then not only will we be suing that college institution, but we will be suing the Board of Responsibility. And if we're going to abdicate the protection of our First Amendment rights to accrediting bodies that nobody can hold accountable for anything, then again, we have a major, major problem. Lastly, I would note that under the ethics rule for psychology, it specifically mentions that you can make referrals for, among other things, personal reasons. And it seems like what I've heard today is that you can make referrals for all kinds of reasons, but when it comes to having a religious reason, we need to be a little careful about that one. And that's called viewpoint discrimination in the law. If I can have a referral for any number of reasons, but religious ones somehow are touchy and we can't have those, then that's viewpoint discrimination. And I'm sure the lady Julia Ward at Eastern Michigan University thought she was protected by the First Amendment as well, which is one of the things that I heard. We have the protections in place. Instead, she wound up spending lots of money and going to the Sixth Circuit Court of Appeals, who smacked down Eastern Michigan University because they violated her First Amendment rights. If we're not going to violate their rights, then let's say so, and I would urge you to pass the bill. I'm happy to answer any questions. Thank you, Madam Chairman, members of the committee.